The matter before the court is York 2468, State of Maine versus the Caliste, Fleury. And counsel are present. If you would identify yourselves by saying your names for the record, together with the party you represent.
Good morning, Michelle King for the appellant, Caliste Fleury.
Good morning, Kyle Myska for the State of Maine, appellee.
Thank you. We are being streamed live on the web, both with video and with audio. And Attorney King, if you're ready to proceed, we'd be happy to hear your argument.
Good morning. May it please the court. Michelle King for Caliste Fleury. 14th Amendment instructs that no one can be deprived of liberty without due process of the law. Here, Mr. Fleury was denied substantive due process because application of the statute in effect at the time of his arrest, which was subsequently amended before his trial, violates the decency of civilized conduct. It allowed for a criminal conviction for trafficking with scant evidence of trafficking, as that term is commonly known. It places him in a position of being convicted of trafficking in fentanyl because he was arrested prior to October 18th, 2021, versus someone who was arrested after, even if they were tried and convicted at the same time. That outcome violates due process in a way that shocks the conscience. Substantive due process imposes limits on what a state may do regardless of what procedural protections are provided. It bars certain government actions regardless of the fairness of the procedures used to implement them. It serves to prevent the government from being used for purposes of oppression.
Counselor, do you agree that in the abstract, it's okay for the legislature to make a criminal statute more lenient only prospectively?
I do, Your Honor, and it is clear from this record that the legislature didn't intend for be applied retrospectively.
And so it's not a violation of ex post facto or any other provision for that abstract. They aren't going to apply it retroactively.
I would agree with that, Your Honor.
So what is it about this case that takes it out of that general proposition and makes it a due process problem?
Well, when we look at due process, we look at not only a factual challenge, but we look at it as applied. And again, if you look at Mr. Fleury's circumstances, the timing of his arrest, the timing of the indictment, the timing of when this bill was filed, it suggests a modicum of unfairness. And I understand if we look at the statute and whether or not it's retroactive, technically speaking, there's no violation.
What is the difference then between this case and State versus Tripp, where there was a change in the Good Samaritan law that would have given the defendant in that case probably a complete defense, and we said it doesn't apply, it's not retroactive? Why is that not governing in this case?
Well, sadly, Your Honor, I think it probably is governing in this case.
Fair enough.
But I'm standing here with what I have.
I understand, and we appreciate that. Can I ask you a little bit different question? The challenge you're raising is really only to count one, is that correct?
I'm sorry, I didn't hear you.
The challenge you are raising is really only to count one in any event, is that correct?
Yes, Your Honor.
And in this case below, it looks like counts 3, although the docket doesn't reflect this on the actual judgment and commitment, it appears that count 3 was merged into count 2.
I would agree with that, Your Honor.
Shouldn't count 2 also be merged into, shouldn't they all be merged into count 1?
I believe the sentences were
they were concurrent, but they're still separate convictions.
Right. That's an argument I hadn't contemplated, Your Honor.
Okay. Well, I guess I'll save that question then for Mr. Myska as to whether they should all be merged.
Did I understand you in your previous comments that you're suggesting that the temporality is a factor that should be considered in the unfairness? In other words, the date of his offense and the date of the amendment? And if they're close together, that is a factor that we would look at in the big picture as to whether or not we should apply the arguments that you're making here today?
Well, when you're looking at the big picture, Your Honor, in fairness, I do think you have to look at the circumstances of each case. That's why it's called as applied substantive due process. It's not looking at everybody as if they stand on in the same circumstances. And here, the temporality of it is actually quite close. So the arrest happened in September of 2020. Mr. Fleury was indicted on April 6, 2021. The bill was filed on May 3rd, 2021, so within a couple of weeks there, and then the bill was amended and adopted such that it took place on October 18th of 2021. And Mr. Fleury's trial didn't happen until 2024.
What is to distinguish, though, this case from any other case in which a law is passed or the statute is amended, any other criminal case in which the statute is amended to provide for lesser penalty or to decriminalize something and yet not made retroactive? I mean, aren't you essentially arguing for a rule that would apply to all cases where charges are pending at the time of amendment?
Well, I'm not asking for a rule that applies, a bright line rule that applies to all cases, Your Honor. I'm asking that you look at this case on a case-by-case basis.
Right, but I'm trying to understand what it is about this case that would make it different from the next case to come along when, you know, a statute is amended to make it more lenient.
So
Well,
if we buy into it here, and someone, this is the timeline for this case, and we say, yep, you've got it, and then somebody comes, okay, my timeline's a little bit longer, aren't we sliding down a slippery slope of uncertainty there that we would end up creating a bright line at some point saying, oh, well, this was X weeks and that was Y weeks. This
Right.
one qualifies, this one doesn't. That's what I was getting at in my original question.
And as one of our colleagues used to say, tell me what the holding of the case would be.
Well, as in all cases, case-by-case analysis, Your Honors, that's the difficult decision about where each case falls and how that's analyzed and where the decision comes. And looking at, I believe, Justice Stanfield's earlier question about whether it relates to sentencing or the substantive part of the law. In this case, we're talking about a conviction on a case for possession of an amount of drug that's 2 grams. And 2 grams or more.
Or more.
Yes.
Quite a bit
well,
more,
2 grams.
actually.
Well, no, I mean the statute, Your Honor, not
Okay. I thought you were
actual-
suggesting he was only possessing.
Oh, no,
2
Your Honor.
grams.
He possessed 18 grams of fentanyl plus another, I believe, 6 grams of fentanyl tablets. So it's a total of 20.
In terms of fairness, doesn't that suggest that at the time that the conduct in question took place that resulted in the offenses being charged against him, presumably he is supposed to have knowledge of what the laws are in the state. So how is it unfair? To the
Well-
extent that when he was acting, the statute in place had this as a defined violation of the law in terms of possession or trafficking, to be precise.
Right. He certainly is held to the accountability of knowing what the laws are at the time, Your Honor. But again, if you look at substantive due process and you compare the fairness of somebody who was arrested in the same time period or maybe just months apart and had a trial at the same time to have somebody convicted of trafficking and yet another person convicted of mere possession and the sentence of that being significantly different, I would suggest when you look at the overall fairness of it.
And I'm still
Well,
looking for what the
let's-
rule of law is as opposed to it's just not really fair.
Let's look at this in a slightly different way because we have 4.5 minutes. The legislature changed the law essentially because they thought it didn't make sense to assume someone is trafficking with only 2 grams. And the judge in this case said, I'm not doing forfeiture because there's no evidence of actual trafficking. So is there an argument here that the statute at the time that it applied to him was irrational because of the subsequent legislative activity and the finding in this case?
Well, I think that's implicit maybe not quite clear in my argument that I made in my brief is that in applying a trafficking charge, if you think of it in the common term of trafficking, is to sell, to manufacture, to do things like that. But the statute that was in place at the time that Mr. Fleury was convicted allows for a trafficking charge for possession.
Okay, so here's my next question. That argument is a little more, has more legs if he only had a very scant amount of drugs.
Like
Can-
actually 2 grams.
Yeah, right. Can he, because he had significantly more drugs on him than that, is he still in a position to argue against the unconstitutional, like a facial claim against the statute, even though as applied, it might have a more rational basis to conclude he's trafficking?
Well, actually, I think my argument on that front has a little bit more teeth. In this case, although he did have 18 grams of fentanyl, there was no other evidence of trafficking. There were no baggies found, there was no scale found, no ledger found, there was no direct evidence of drug activity. We have nothing but the amount. And we do have $908 that was found on Mr. Fleury, but there was no testimony from the officer tying that particular amount to any type of drug activity, no testimony that the denominations that were found could be linked to drug activity. There's essentially nothing except the amount of fentanyl found on...
Which is why forfeiture was denied, correct?
I'm sorry?
That's why forfeiture was denied, correct?
Correct, Your Honor.
But that amount would have been, or could have been enough to convict him of possession with intent, trafficking based on possession with intent to distribute, which remains in the statute, right?
A permissible inference, Your Honor, that can be overcome by other evidence or lack of other evidence
But
with regard to...
The amount and the amount of the contraband and the amount of the money could justify a jury verdict convicting him of possession with intent to distribute, irrespective of the 2-gram amount, correct?
Unfortunately, we won't know that because the jury was instructed that all we needed to have in this case was possession of 2 grams or more. So had the jury been instructed differently, that they could have considered a permissible inference and all of the other evidence of or lack of evidence with regard to trafficking, we would be looking at a different situation. But the jury was instructed that all the state needed to show was 2 grams or more.
And possession with intent to traffic is not a Class A aggravated trafficking carrying a mandatory minimum 4-year sentence.
Correct. If there are no further questions.
It
Thank you.
doesn't appear to be. And Attorney Myska.
Good morning, Your Honors. Chief Justice Stanfill, may it please the Court. Caliste Fleury was convicted of aggravated trafficking in scheduled drugs, unlawful trafficking in scheduled drugs, possession, and OUI for conduct he committed on September 18th of 2020. On October 18th of 2021, some 13 months after his criminal conduct was committed, a statutory amendment went into effect, changing one of the definitions of trafficking under Maine law. Essentially, Title 17A, Section 1101 was amended, removing the definition of trafficking, which is to possess 2 or more grams of fentanyl. Importantly, the legislature did not include any additional language when it made this particular amendment. The reason that's so important is the Court has already keyed in on Title I, Section 302 specifically states, and I quote, "The repeal or amendment of an act or ordinance does not affect any punishment, penalty, or forfeiture incurred before the repeal or amendment takes effect." Section 302 further states, "Actions and proceedings pending at the time of the passage, amendment, or repeal of an act or ordinance are not affected thereby." In January of 2024, this Court had the opportunity to apply that statute in a criminal case. There, in State v. Tripp, as the Court has already noted, there was a defendant who was claiming Title 17A, Section 1111B, which would provide him with a certain amount of immunity for certain conduct, was amended while his case was pending, and that he should have the benefit of the amended statute, which would grant him with greater immunity, applied in his case. However, this court stated that Section 302 provides a general rule of construction which is controlling absent clear and unequivocal language to the contrary. There, the legislature included no such language in the amendment to 1111B, and because it was held that in a criminal case, punishment, penalty, or forfeiture is incurred specifically when the conduct or crime is committed, the appropriate statute to apply was the one in place again at the time Tripp's conduct was committed. Likewise here, Mr. Fleury's conduct was committed on or about September 18th of 2020. The statutory amendment did not go into effect until October 18th of 2021. That subsequent October 18th, 2021 amendment did not indicate even an intention to make that amendment apply retroactively. That's the only way that Section 302, which is a general rule of construction, can be overcome, and therefore application of the amended statute in Fleury's case is absolutely barred. Furthermore, this court in Tripp found that it wasn't even necessary to consider whether or not Tripp's constitutional rights were violated by application of the retroactive law, or by retroactive application of the amended law, because the appropriate law to apply was in fact the one that was in place at the time of his crime being committed. Now, this holding highlights an important distinction before the court today. Fleury, just as Tripp did, is trying to claim that his constitutional rights have been violated by not applying the amended law, but that's not the appropriate analysis. The appropriate analysis instead...
Well, let me ask this question. Do you think that there is some minimal level of possession of a controlled substance that it would be irrational to presume that definitively that the person who is possessing it is engaged in trafficking?
So if I may just clarify, you're asking at what level?
Is there a level at which, if you had a scant amount of drugs on you, that it would be irrational to definitively presume that you're trafficking?
Well, I wouldn't say the amount to be scant. I would say there is a certain level where, yes, at a certain level...
Okay.
It's really not rational to assume they're trafficking.
Yes, Your
at a
Honor.
certain level.
And do you think that 2 grams, I mean, the legislature subsequently said it didn't make sense, and the court here found there was no other evidence of trafficking. So was the statute, before it was amended, can it be argued that it was irrational?
Well, first and foremost, there was testimony by Sergeant Thomas Pappas with Maine State Police that in his training, education, and experience, the 20-plus grams of fentanyl, as well as
I know he had
$908 in
more
cash.
than 2 grams on him.
Yes, Your Honor.
So that raises the separate question of whether he could properly raise a challenge to the statute itself that only required 2 grams. And I'm asking the harder abstract question about the 2 grams. So is it rational to presume that someone who has 2 grams on them is trafficking?
Your Honor, I would say that it is a difficult question to answer simply because the drug world has been evolving. So when I first started doing this, when I used to see people who were in possession of 5 grams or 10 grams, that was a very significant amount of drugs. Nowadays, we're seeing people, unfortunately, with greater and greater quantities because it is more and more available. And I do think that there was a rational tie to the legislature's initial law, the one that was in place at the time of Fleury's conviction, because the government was trying to combat the overwhelming spread of fentanyl in the state. It's a disease that unfortunately claims all too many lives in the state, so I do think that there was a rational component there in saying that at a certain level we are going to presume trafficking.
But interestingly, that was not, well, the way the statute was, it was a conclusive presumption, really, for a jury. In other words, if there was 2 or more grams, it
Yes, Your
was
Honor.
trafficking. Section 1103, subsection 3, has various provisions in which it is at least possession of a certain amount of different kinds of drugs can be evidence of trafficking, essentially.
Yes, Your Honor.
But they didn't, when they repealed the 2-gram definition, 2 grams of fentanyl being of possession being a definition of trafficking, they didn't then add, but it could be considered. And they didn't seem to amend it to add any presumption like that or any inference for possession of fentanyl. Am I right?
No, Your Honor, there's actually a permissible inference for trafficking in fentanyl and heroin. Specifically, that amount was changed, so it's no longer 2
Okay.
grams, it is 4 grams,
Uh,
if I recall the statute correctly.
Okay, I guess I'm just
It might be
missing
the
it.
most recent iteration that
Okay,
the
I may
permissible
be
inference
missing
is
it.
at 4
Can
grams.
I ask a different question?
Of course, Your Honor.
As the question that I asked Ms. King, in this case, it's my understanding that the court ordered count 3 merged into count 2.
Yes, Your Honor.
The docket doesn't reflect that, by the way, only the judgment and commitment does. But why shouldn't they all be merged into count 1?
Your Honor.
Assuming we allow count 1 to stand as it is.
Yes, Your Honor, and the way I would explain it is this, is the state's theory rested upon 2 different baggies of fentanyl that were found on Mr. Fleury.
There's the pills plus the baggie.
Correct, Your Honor. So the aggravated trafficking charge, and this was made clear at sentencing, was based upon the 18-gram bag that was found on Mr. Fleury. There was an additional bag of 53.5 pressed
But even
pills.
if there's 2 different theories, when we talk about merger, don't we look at how the elements and the charge? I mean, I don't see how, as charged, if he's found guilty of count 1, that doesn't mean he also how he could not have also committed count 2.
I would agree, Your Honor.
I mean, it doesn't change the sentence necessarily. It's a question of how many convictions there are.
Correct, Your Honor, and I would say that under the circumstances, the state's theory was that the pressed pills, only a few of those pills were tested according to the HETL Labs 9550 testing policy. So under the circumstances, the state went forward on the unlawful trafficking in the alternative.
I understand why it was done. I'm just
Yes, Your
the
Honor.
question is, having found him guilty, the jury having found him guilty of all of those counts, including trafficking, actual trafficking, so which makes the forfeiture ruling somewhat curious.
And I can speak to that if you'd like, Your Honor,
No,
but in
it's
the
okay.
grand scheme of things, I do think that the second conviction could absolutely be merged with the first.
Okay. So you wouldn't object to having them all merged into the 3 drug cases being merged?
Correct, Your
into-
Honor, and I think that at sentencing, there was a lot of discussion regarding the danger of pressed pills in particular.
I understand.
So under the circumstances, I don't think it would change the sentence whatsoever, just as you stated, the convictions for which he was found.
Okay, thank you. There don't appear to be additional questions. Thank you.
Thank you, Your Honor.
And Ms. King, I don't know if you needed 2 minutes of rebuttal in this case.
It's going to be a slow process of my figuring out what to save and not to save here on, and whether to save any at all, but I'm taking it each case as it comes. Mr. Fleury's substantive due process rights were violated when he was convicted and sentenced on trafficking in fentanyl with no evidence of trafficking as it's commonly known at all, and I would suggest to you that this court should vacate his convictions on that front.
And I assume you have no objection to us ordering counts 2 and 3 both merged into count 1 if we sustain the conviction on count 1.
I'd be delighted, Your Honor.
Okay.
Thank you.
Thank you, counsel. As is our usual practice, we will take the matter under advisement and issue a decision in due course. Thank you.